Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. Accordingly, the information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today I want to talk with you a little bit about the type of property two people in a marriage or a registered domestic partnership can own. This is the first video of a 4-part video series. If you live in California, then you need to know about community property, quasi-community property, and separate property. That's true especially if you're married or in a registered domestic partnership. All assets of a single or unmarried person are the property of her and her alone. Nobody else has any present interest in those assets. Also, those assets are not subject to payment of debts of anyone else, absent some kind of an agreement, a court order, etc. In California, the assets of each person in a marriage or registered domestic partnership are one of 3 types: community property, quasi-community property, or separate property. Community property are all assets acquired by either spouse during a marriage and while living in California. The word acquired means or implies gained through personal efforts. Employment income of either or both spouses is a perfect example of community property. Each spouse or registered domestic partner has complete control over community property assets, with some exceptions. One exception is that transfer of real property or real estate ownership requires the signatures of both spouses or both registered domestic partners. The theory behind community property is that both spouses or registered domestic partners are a team working together. Perhaps the wife forgoes employment income to raise children in the home and in the household, while the husband goes out into the workforce and works and generates income from employment for the marriage. The theory is that the husband would not be able to focus on work in that way without the efforts of the wife at home. Accordingly, the wife has as much of an ownership interest in the husband's employment income as the husband has in his own employment income. Most likely, at least some of the husband's community property income will become a community property asset, whether cash in a bank account or transferred into an investment account, spent to purchase a vehicle or a house, etc. Again, each of the husband and the wife have equal ownership of and complete control over each community property asset, again with those limited exceptions. The same is true regarding employment income and assets acquired in another community property state prior to moving to California. And there are 9 total community property states: Louisiana, Texas, New Mexico, Arizona, California, Nevada, Idaho, Washington, and Wisconsin. Planning ahead for transfer of assets after your death can be very complicated. There are many factors to consider, including who you want to receive the assets. Also, consider how easy you want to make things for your relatives after you die. If you don't do this correctly, then you may create confusion and even conflict among your family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning and transfers of assets, or even if you just have a question, please contact us and let us take care of you.